everyone, this is Poonam Harjani, leader of Taxmann's Advisory and Research Support Services. Taxmann's Advisory and Research Support team comprises of distinguished experts on income tax and GST matters to support businesses in being fully tax compliant, optimizing tax positions, and mitigating litigation risks. In today's video, I am covering the key highlights of the recent Gujarat High Court ruling regarding deduction towards value of land for computing GST liability or construction services. Honorable Gujarat High Court in case of Munjal Manish Bhai Bhatt versus Union of India has held that the developers can deduct the actual value of land given under construction contracts for discharging GST liability on construction services. Before we deep dive into the specifics of the ruling, let's understand the legal issue involved in the writ petition before the Honorable High Court. As the name itself suggests, the good and services tax is levied on supply of goods and services or both. The sale of land or building is outside the GST nest since it is neither a supply of goods nor supply of services. However, if the consideration, whether fully or partly, relating to construction or development of land or building is received by the developer before the issuance of completion certificate, where it is required, or before the first occupation by the buyer, the GST is payable on construction services provided by the developer to the buyer. As such, the transaction involves two components. One, supply of construction services, and two, supply of land. For levy of GST on construction services, the value of land needs to be deducted from the contract value. In other words, the value of construction services equals total amount charged for sale of property minus the land value. Now the question arises how to arrive at the land value so as to deduct it from the contract value. In this regard, the Central GST Act Notification number 11 of 2017 deems the value of transfer of land or undivided share of land as 1/3 of the total value of the contract for the subject property. Similar provisions also exist under the state GST legislations, and all states have issued notifications on similar lines. The developer is required to pay GST on the balance 2/3 value of the contract, and this is irrespective of the actual value of land and whether such actual value is separately mentioned in the construction contract or not. Now, what is the anomaly in this deemed valuation provision? These days, in many cities, we note that the value of land exceeds far beyond 1/3 of the total contract value for the property. In many cases, in fact, it may run up to 70 to 80% of the contract value. As per the government notification, however, the deduction is still only allowed to the extent of 1/3 of the contract value. This leads to GST incidence on value of land by treating them as construction service. And the developers are thus compelled to pay extra GST to the extent the value of land exceeds the 1/3 value of the contract. The judiciary has taken note of the said impugned deeming fiction and has said that it is arbitrary and it is being uniformly applied irrespective of the size of land, extent to which the construction is being undertaken, etc. Given this, the High Court has held that such deemed value of land to the extent of 1/3 of the contract value is arbitrary, discriminatory, and is thus invalid. The actual value of land is separately available. If it is separately available, is deductible. Following are the key highlights of the ruling. 1. The High Court has held that such deeming fiction in the government's notification is contrary to the scheme of the GST Act and thus needs to be read down only as an optional method for discharging the GST liability. Two, the High Court has held that the sale of developed land by developers to the ultimate customers cannot be subject to GST since the sale of land is outside of the GST net. 3. The High Court has followed the earlier Supreme Court ruling in case of Wipro India, where the customs valuation rules provided for mandatory addition of loading unloading charges on deemed basis. And the Supreme Court in that case similarly read down the provision as an optional provision and is not to be applied where the actual value of loading unloading charges were available. Fourth, the Honorable High Court has rejected the revenues plea that the mandatory provision should be sustained for the fear of manipulation in apportionment of land value by the contracting parties. The High Court has taken note of the fact that the GST law already contains anti-abuse provisions to take care of such scenarios. It is highly likely that the government moves to the Supreme Court against this Gujarat High Court ruling. Keeping that possibility aside, let's look at the following immediate repercussions of the ruling. Firstly, the developers can avail the actual value of land as a deduction from the contract value to pay GST on construction services. To adopt this approach, it is advisable that the developers intimate their jurisdictional GST authorities about discharging GST liability following the ratio of the Gujarat High Court ruling. The developers who have already passed off the incidence of GST to home buyers may not be entitled for refund. However, if they have paid tax under protest, they may explore the possibility of getting refund. For ongoing contracts also, the developers can explore the possibility of passing on the benefit of the tax charged extra on previous installments and seeking a refund back from the GST authorities. The property buyers can also look at the possibility of getting refund where they have borne the incidence of GST. In case of developed plots, similar principles will apply. In case the incidence of the GST has been passed by the developers to the buyers should explore the possibility of seeking refund. Else, if the developers have been paying GST under protest, the developers should apply for refund. There are several developers who are bound by the unfavorable advance rulings or appellate advance ruling orders. They will need to approach to the relevant higher forums to get appropriate remedy based on the Gujarat High Court ruling. And lastly, the implications of these rulings under the other instances under the GST law where there are mandatory valuation or apportionment prescribed, the implications need to be examined. For example, the EPC contractors who supply solar power generating systems to solar power developers, they have a requirement to mandatorily apportion the value of goods as 70%. Whereas, as per the industry's claim, the actual value of goods involved typically runs up to 90%. Such contractors may also look at the possibility of challenging this mandatory apportionment between the value of goods and services based on the Gujarat High Court ruling. That's all from my side for today. Before I close, I want to acknowledge the contribution of my team, Sunil, Karishma and Yamini, and our marketing support team in creation of this video. And I thank you for watching this video. Do not forget to log on to our portal www.taxmann.com/advisory to know more about our advisory and research support services. Thank you and have a good day.